A very warm welcome this afternoon, colleagues, and a welcome to our afternoon session, the School of Law Student Induction Workshop. I am Professor Benson. I'm the acting head of the Academic Quality Assurance and Enhancement Portfolio in the College of Law. And we are thrilled to have Professor Sibanyoni, who will be our program director this afternoon. So, Prof. Sibanyoni, the floor is yours, sir. You may take us through the day. Thank you.
Thank you so much, Prof. B. This is me one. Thank you so much, Prof. B. Welcome, everyone. I'm Professor Ephraim Kevin Sibanyoni. I'll be your program director today. I come from a School of Criminal Justice, Department of Corrections Management. Today it's exciting, as since actually yesterday, it's exciting that we are conducting this series of induction to students so that you know what's what, so that you are on a clear and for you to have a feel and have a face-to-face engagement with us. I know that sometimes you have various questions and you feel like we are at the ivory tower. So our College of Law, it's here for you. We are by you, therefore we are here for you. Please have your questions on the chats. We will have our Q&A at the end of this engagement. Please ask questions as much as possible. When you leave the platform, be on a clear, have a clarity. You know, all the burning questions that you've been having, jot them down on the chats or during our Q&A, raise your hand. So today it's all about the goodies at the School of Law. So without wasting any time, is our director, Professor Dube, in the platform?
Thank you so much, Professor Sibanyoni and Professor Benson, for having me here today. I hope my lighting is on. I think I can see myself, which means everyone can see me. Good afternoon, colleagues. Good afternoon, students of the University of South Africa. As introduced, my name is Professor Angelo Dube, Acting Director of the School of Law. My task is very brief. I will not be staying long, unfortunately, in this gathering because I need to dash to other engagements of the university that I've just come from before coming to this gathering. However, you are in safe hands, in the hands of the colleagues that I'll be leaving you with when I exit from here. This is a very important gathering for our college to interact with our students so that they get to know what lies ahead for them and what our college looks like, how it's constituted, and how we do things. You will notice, if you haven't already seen that we have 5 departments within the School of Law. And those departments make up the School of Law, which together with the School of Criminal Justice then make up the college. We have the Department of Public, Constitutional and International Law. We have the Department of Private Law, we have the Department of Jurisprudence, we have the Department of Mercantile Law, and then we have the Department of Criminal and Procedural Law, the types of law that you will require for your procedures when you go to court to represent your clients. As a school and broadly as a college, we are interested in student support and engagement. That is why we have platforms such as this, where we engage with our students. They get to see the faces behind the college. The departments are assisted by various portfolios. You have Professor Benson right here, who's in the quality assurance portfolio. Her portfolio does a very important role for the university, ensuring that everything that we do is quality assured and reflects the status of the University of South Africa. For example, the exam papers that you get through her office, and her team goes through them and ensures that they are quality assured, that we're not giving out questions that are not on par with the NQF level at which we're supposed to be assessing you. Over and above student support and retention, we also have other core curricular activities that we have where we try to ensure that our students come out well-rounded. For instance, we do have the law clinic that runs our student support activities. Some of these include the moot court competition, which allows our students to engage with effectual metrics and hypothetical and apply the law to that imagined real-life situation and present a case on behalf of their client before a bench made up of judges, advocates, attorneys, and so forth. We also have the student debate and endeavor that we run through the law clinic, but I'm sure representatives of all these departments will come here and address you so that you know what is it that we have that you can engage yourself in as a student of the University of South Africa. But all those different activities and engagements and projects are aimed at ensuring that the UNISA graduate comes out as a well-rounded, industry-ready graduate. We are in constant contact with the Legal Practice Council to ensure that the graduates that we produce contain the graduate attributes expected by the industry, to ensure that we do not produce a lawyer who's going to go out there and bring damage to the reputation of the university or bring damage to what we stand for as the College of Law. We believe in our students, we believe in our graduates because we give them only the best. We produce the highest number of lawyers in South Africa. When I sit in the meetings of deans of law colleges or law faculties in South Africa, and sometimes we compare numbers and you hear one dean saying, my final year class is 200 students. And that's all they're producing. Another one says, my final year class for the LLB is 50 students. And here comes UNISA saying, we are somewhere in the region of 4,000, 5,000 that we are producing at a given time. So we produce the biggest number of lawyers across the region because we have the numbers. So it's imperative for us to ensure that we produce the best of the best of the best. Hence, we have all these programs and projects that we have in place that are aimed at supporting our students. I am sure by now you've heard about the 10 catalytic niche areas that the university is pivoting around. Some of those areas include health and medicine. Some of them include the square kilometer array. Some of them include space studies. Some of them include energy. Some of them include marine studies, as well as aviation and aeronautical studies. The college is heavy on ensuring that our students are taught and they are introduced to research in these various niche areas. We have a lot of exciting projects that we have come up with, such as the Engage project, Engage scholarship project on the rural aviation economy. It's an aviation-related project that we got approved last year. Over and above, so many others that are looking at youth and how to develop our youth across the country. Colleagues, at this point, I think I've pretty much summarized what we do within the School of Law and within the college. My task was largely to just welcome you and say, may this gathering be useful to your journeys as students, and may you have fruitful deliberations going forward. I thank you.
Thank you so much, Prof. Dube, for that insightful opening and welcoming. I'm sure some of the things you attached are the CODs they will talk about. Students, you are in capable hands. All the colleagues, staff in the college, in the School of Law, they are fit for the purpose, and you will agree with me to say that we are the biggest, we are the University of the Land, we are biggest even in Africa, as our director alluded that we produce over 4,000 to 5,000 students So that tells you the magnitude of our institution. And of course, in the School of Law, there are 5 departments that makes up a school. With that in mind, I will now ask the CODs. When it comes to UNISA, when we say COD, we are referring to HODs. So CODs are actually heads of the department, but we call them chairs of the department. We have 5 that will do their presentations, and each will be given 10 minutes. We have Prof. Sarombe, as a COD, Department of Criminal and Procedural Law. We have Dr. Mahlobohwane, COD for the Department of Jurisprudence. We have Advocate Mtembu, Department of Mercantile Law. We have Prof. Baka, Department of Private Law. And lastly, we have Dr. Ndlazi, COD for the Department of Public, Constitutional, and International Law. Prof. Sarombe, may I ask you to ascend the podium, and your 10 minutes starts now. Thank you so much.
Professor Sibanyoni?
Yes, Prof.
My sincere apologies. Advocate Mtembu has an emergency in her department and she's asked to present first. So please, could we afford her the opportunity? Thank you.
Absolutely, absolutely. Oh, there. Yeah, okay. Thank you so much. Advocate Mtembu, over to you, please.
Good afternoon, colleagues. Good afternoon, students. Good afternoon to college management. Thank you for affording me this opportunity as I share on my screen the presentation on behalf of Mercantile Law Department. Just give me a second, colleagues. It's still loading. Please do indicate if you can see my screen. We are the Mercantile Law Department, the biggest department in the College of Law. Just to indicate to you, colleagues, I am Advocate Mpagwana Anastasia, the chair of Mercantile Law Department, as I have been introduced. I would like to introduce to you the colleagues in the Mercantile Law Department without going through their names. The colleagues in the department, we have 3 professors. We have associate professors, 16 of them. We have senior lecturers, 17. We have contract lecturers, 2 of them. And then we have 2 permanent contract lecturers. And then we also have 2 contract senior lecturers. We also have postdoctoral research fellows. There's 3 of them. With regards to adjunct academics, we are having 14 adjunct academics. We also have permanent support staff members. We have 1. We have a contract support staff, that is also 1. And then the last contract support staff has been seconded from another department. With that said, colleagues, I would then just go through the qualifications or the streams which are offered in the Mercantile Law Department. As I indicated, Mercantile Law Department is the biggest department in the College of Law. We are having 70 modules in the department with the 8 streams that are showing on the screen, which is banking law, labor law, corporate law, intellectual property law, commercial law, insolvency law, insurance law, and the last one being the tax law. These are the streams that we have. So most of our modules commence at 2nd year level, unless you are registered for a BCom law, then we have service modules which are at 1st year level. From 2nd year level, we have modules from corporate law, labor law, then as well as commercial law. Insolvency law, insolvency law is at 3rd level. We have insurance, tax law, and corporate law, intellectual property law, also at the 4th year level of your studies in the LLB. If you are registered for your 4th year level, then you're able to choose a specialization based on the selection or the elected modules that you will choose. For example, if you want to specialize in tax law, then you'll have to register for LML 4804 in your 4th year level, because that will be required in order for you to be admitted for a master's in tax law. So ensure that when you are choosing modules for your 4th year level, if your interests are with mercantile law, the catalytic department, which is an agent of change, choose correctly to ensure that you become an expert in an entrepreneurial law, tax, as well as technology. Who should we contact in mercantile law when we're dealing with administrative issues? Probably looking for a lecturer, you can't get hold of the lecturer. You're looking maybe for assistance from the chair of department's office. We do have 3 ladies. We have Miss Lerato Sitole. You can contact her at the email address that is appearing on the screen. She is in the COD's office. She is the secretary in the mercantile law department. We also have Miss Sibia, who is assisting us with undergraduate modules, queries, undergraduate modules, lecturers. Should you have any query or need to contact any of our lecturers, she is the person to go to. Lastly, we do have Miss Mutibedi, who is responsible for postgraduate modules. If you then intend to pursue your further studies in mercantile law and be a specialist in tax law, intellectual property law, corporate law, labor law, banking law, insolvency, insurance, lastly, commercial law, the person to go to is Ms. Mutebedi. Please do take note of the fact that when queries are being sent to the academics and the lecturers in the department, those queries must be module-specific queries. When you're sending an email to either a query about the content, or you are unable to get hold of your study material on My UNISA, please ensure that you send an email with specific query information to the module leaders. We have, remember, students, we have 70 modules in the department, and the colleagues in the department are teaching between 3 and 6 modules. So if your query is vague, it becomes difficult and also takes some time for you to be provided with the necessary support that you require. So state the module code, state the specifically module content query. For example, I'm finding it difficult to understand the discussion which relates to issues of banking and stokvel, which leads to financial inclusion. Then that makes it easier for your lecturer to be able to respond to your query. As I have indicated, join the department, which is the catalytics of change, the leaders in business, law, and technology. I thank you.
Thank you so much, Advocate Mtembu. That was short and sweet. Students, take note that within the university, we work within a structure. All the module content queries, they go directly to your module leader or your lecturer and secondary lecturer. Any other administrative queries, they go straight to the relevant department, and we are going to have the relevant department that will be presenting, and you can source out the contacting details. And I hope for your sake, you took the contacting details of all the administrators within the department, so that when you have any queries, you can send your queries directly there. Thank you so much, Advocate Mtembu. Now I'd like to invite Prof. Sarumbe. The platform is yours, Prof. Prof. Sarumbe?
Yes, I'm right here. I'm just trying to share good Afternoon.
Afternoon, Prof. Prof,
Yes.
when you see my face, just know that you need to wrap it up.
Yes,
Thank you
no,
so
I
much.
won't be long. Are you able to
Thank you,
see
Prof.
my slide?
Yes, you can put in presentation mode. Thank you.
Yes. Is it in presentation mode now?
Oh yeah, it is, Prof. Thanks.
Just to also show my face. I don't know if you can see me. So that can you see me?
Yes, there you are, Prof. We can see.
Right.
Thank you.
Yes. Thank you so much for the opportunity, and I really appreciate that this induction comes at this particular time. We are the Department of Criminal and Procedural Law, and we call ourselves a cornerstone of the department in terms of practice, because most of the practice modules are taught here, your criminal law and procedural law modules. So without this department, your legal profession actually means nothing. So we are quite, even though small, I heard Advocate Mtembu speaking about the biggest department. We are together there in terms of the importance. And this is indeed our department. Let me go to the second slide. Right. As you have seen, we are part of the School of Law, and we are striving towards being the leaders in offering social relevant legal research and education. And on that aspect of legal research, you will see that the modules that you will do at third and fourth year level, they also speaks to the issue of building research capacity for our students. But let me just start by speaking about what our mission and value is, because of the social fabric of our country, of our continent and the world. It is very important and critical that we produce ethical lawyers who are able to respond to the needs of our nation, the needs of our continent, and the global needs in the legal fraternity. And we are therefore creating an enabling and collaborative environment for success. So we say in the department, our students, you are our partners to success. You are not alone. Without you, we cannot be able to achieve what we have to achieve. So in the big modules that we have, especially in the criminal law group, you will notice that our lecturers there, they are quite capable and able to take you through how these modules are offered and what exactly that we need to achieve there. So key deliverables that we have, the delivery of a comprehensive LLB curriculum. And in that curriculum, we do have 15 modules that are core modules that I will deal with as we go along. And within those, we have got 15 teaching staff members and 7 fixed-term members and 3 administrative staff. And we are a dedicated team that is also led by myself. Then if you look at the groups that we have in the criminal law group, we have got CRW 2601, 2602. These are all modules that share similar principles, but then we also even go on to the advanced level at the postgraduate level. And these are compulsory modules that all of you know they are, and they form the critical and the bedrock of the LLB program. You cannot go and graduate or even do other modules ahead without doing these basic modules. So the procedural modules, the criminal law is there, criminal procedure is there, civil procedure is there. So this is our department that offer such important qualifications for you. The staff profile that we have here is we have got 2 professors, full professors, and this is Professor Landy Bauer and Professor Bobby Nudea. Professor Landy Bauer is with the criminal law group, and Professor Bobby Nudea is with the law of evidence. And these are leaders in their own right, and they are leading in the offering of these. But within the criminal law group, we have got associate professors also there with Professor Molema, Professor Naidu, and senior lecturers, Ms. Diseko, Advocate Mseka, and these are within the criminal law group, and they share the modules there. And then in civil procedure, we have the subject head, we have got Dr. Njazi, and we have got Advocate Mutapo. We have got also Advocate Mapula, who is also there. We have, as part of our associate professors, leading LME, one of our research modules, that is Professor Pinar, and also we do have Advocate Kutsia. We also have in the research group, we have Professor Munyakane and Ms. Kwane. But within the research group, you will notice that the production or the capacitation that you need to have for you to produce a research portfolio is very critical and important for the College of Law. And without the RRLLB, which is our research module, you will not be able to be a good researcher. So the skills that you receive here are very important and critical for your needs. And you see that 7 senior lecturers means that these lecturers also are still, some of them, busy with their studies and going up the ladder. The important thing about the lecturers who are also busy studying is that they are studying within the context of the modules they teach, and they are also able to unearth new things that are happening. So let me give you an example. Our department has got 2 professors who are responsible for the revisions of the Criminal Procedure Act, if you are aware. And these are at the center of renewal of our law within the Law Research Commission, and they are doing very well. That is Professor Mulema and Dr. Mkwena. And it's very critical and important that when they are developing this new knowledge, you are part and parcel of that project, because they give you that insight or that head start, which you will not find anywhere else. Then the lecturers, we only have 1. Then, of course, postdoctoral fellows, it may not be necessarily critical for you to know about this. I will then move on to admin staff. I have got 3 admin staff. Ms. Jane Matebe, who is in charge of the chair of department's office, which is my office. And she is, busy here managing my diary and making sure that I attend to all your queries that come straight to me, and be able to make sure that she directs the queries to the relevant lecturers or to the subject groups. Then we have Ms. Shwene Mabosha. She is the one in charge of study material. Your tutorial letters, before you receive them, she gets them and uploads them onto the system and make sure that you receive the right material within the right modules.
Prof,
Then we
can you see that slide? Sorry.
Oh, my slides are stuck here. I don't know what is happening. I'm going to try. I'm going to try and see. Because I have got their names there and their pictures and their contact details. I don't know what is happening. I can't move the slides, Prof.
Yeah, it's fine, Prof. You can share in the chats. We can obtain.
Yeah, I can share within the chat even when I'm done. Right.
All right. Thank you so much.
Yeah. Then we do have Miss Karin Rosen. She is in charge of our repository system and also the departmental website, to make sure that all of us here, we are identified within the modules that we teach and our contact details are up to date. and you can be able to see who you are looking for just by going onto the website of the department. Over and above that, she also captures the examinations in terms of making sure that the integrity of our exams are not compromised. And she makes sure that you get your exam paper on time, and you also write on time. And she records all the details that we need. So the repository system is in her hands. But also she is in charge of postgraduate studies and research. So for those who are doing masters and doctoral degrees, you will notice that Ms. Rosine is the one who is working with me when I am allocating students to specific lecturers. She would be doing the administrative stuff to make sure that once you give us your topic, we give you the right expert to deal with the research that you are in charge of, and thereafter you comply also with the formalities that are required. Of course, there's the tutorial letter, but there's a human being that is behind the tutorial letter on how you can undertake your research. So she provides for that research, for that expertise. And then students very encouraged, especially those who are approaching their final year, to do a research in the RRLLB that is relevant to what they even want to do at postgraduate level. I, for one, what I discovered to be my interest, especially, I discovered it when I was in third, fourth year, and I moved with that specialty up to PhD level. So it's not too early to know and identify what you want to do. And I encourage that you do your research module within the topic that you like, that you can move on with it to postgraduate level. And if you write very well, like some of our students are, they even publish that paper that they produce in the LLB degree. One of our students, mentored by Professor Mulema, entered the competition where I think he won the Ishmael Muhammad essay competition. And I think he was just at third year level. So from our department, went to national level and scooped the trophy. And we are indeed a leading college, a leading department within the College of Law. I'm sorry about the glitches. It will be sorted out so that the slides, you find them in the chat.
Yes.
Prof. Isbanyoni, I see there is a hand. I can take a question if there is.
Chair, may I ask the student to write the question on the chat, and then you can kindly answer from that angle, and or otherwise at the end of the session, we do have our Q&A. If the question is pending, please write it on the chats, and or it can wait to our Q&A session. Prof. Sarombe, thank you so much for your department profile, and we are really proud of the department's achievement, and specifically the competition that the student won at the national level, and how prolific students write under the guidance of their supervisors, and rightfully so, as you have alluded, Prof, that students are our partners, and we need to work hand in glove to realize their dreams of becoming a top tier lawyers all the way from University of South Africa. Thank you so much, Prof. Sarombe. May I now invite the Department of Jurisprudence, Dr. Mahlobohwane, you can ascend the podium. You can show your face, and your 10 minutes starts now. Thank you so much.
Thank you very much, Professor Sibanyoni, Program Director. I'm not sure if my presentation is flighted on your side, Prof.
Yes, it is. You can put it on a slide mode.
Okay. Slide. Is it okay now?
Yes, it's okay. Thank you, Doc.
Okay, thank you. I'm now trying to put my camera on. Okay, is it visible from your side? I can't see anything from my side.
Yes, we can see you, Doc. Thank you so much.
Okay. No, thank you very much. Yeah, let me start by the formalities and thank you, Program Director, Professor Spagnoni, esteemed colleagues, and most importantly, our first year students, whom I would like to call the future legal minds of South Africa. I wish to say to you, good day. And let me plead with you that I do not put my camera on for long because I'm afraid that it may interfere with my presentation in the long run.
Yes,
But I will
okay.
switch it off in the meantime.
Yes.
Yeah. Firstly, let me rather say welcome to the Department of Jurisprudence. In this department, we do not merely teach you what the law is. We actually challenge you to ask what the law ought to be. So I'm going to introduce you to some of the modules, first year modules that are compulsory in this department. So I'm not going to run through all the modules in the Department of Jurisprudence. My slides will indicate the reason why I choose to do that, but allow me to switch off my camera. Okay, this is my first slide. And yeah, what is happening now? Okay. My slides are not moving. Apologies for that, colleagues. Oh, yes. This is me. I'm the acting chair of the Department of Jurisprudence, Dr. Franz Mahlobo. And let me introduce you to the staff members within the department. We've got 5 full professors. We've got 4 associate professors. We've got 8 senior lecturers, 7 lecturers, and 3 administrators. In total, we have about 27 staff members. And who are we? My slides are self-explanatory. Our mission is to create a supportive environment that enables you to become a critical, independent, legal professional. I have already indicated that in the Department of Jurisprudence, we're not only teaching you or telling you about what law is, but we challenge you to think on what law ought to be. The role in the Department of Jurisprudence, we are saying we are responsible for teaching foundational modules that set the stage for your entire LLB degree. So we seem to be the department that houses most of the first year modules. Hence, we are saying we're teaching the modules that set the stage for your entire LLB degree. How many modules are we offering in the department? We have about 13 modules. However, of relevance to this induction, I have limited my induction to the first year modules that are compulsory. That I'm just hoping that most of you have registered for. These are the compulsory modules. The department offers 4 core foundational modules that most first-year students must complete. We have as the first one, skills course for law students. And the goal of this module is actually to help you develop critical reading, writing, and analytical skills that are necessary for the world of legal practice. I'm just hoping that you have already gone through your study materials, and maybe some of you, I know for sure that you have already submitted your first assignments, and you may have realized exactly what I'm talking about here. And the lecturers for this module, we have 2 lecturers in this module. This is Advocate Mokomane. I struggled to find a picture for the secondary lecturer, Mr. Muremi. So these are your lecturer. Advocate Mokomani is your module leader in this particular module, SCL 1501. And continuing with first year compulsory modules, we have Introduction to Law, which deals with underlying principles of South African law and the concept of transformative constitutionalism. What is the goal? The goal is to help you as our law students to distinguish between basic legal concepts and apply rules to elementary legal problems. So as you begin foundational modules, like the 2 that I have also already spoken about, which is skills course for law students and introduction to law, you will then realize that jurisprudence is the philosophy of law. So it is in this department that you will probably grapple with the big questions like the relationship between law and morality, the meaning of justice, and the impact of unique African concept of Ubuntu on our legal systems, or rather legal system. And this is the module leader for Introduction to Law, Ms. Annalise Jacobs. On this one as well, I could not find the picture for the secondary lecturer, Dr. Lungisineke. But those are your lecturers, students. Continuing with first year compulsory modules, we have the third one, Origins and Foundations of South African Law, which deals with the historical development of the South African legal system, including indigenous African and Western traditions. The goal of this module is to help you understand how historical traditions and the Constitution shaped our current legal framework. And this is one of your lecturers for HFL 1501, Ms. Andrea Bowling. And the second one will be Ms. Lizen Veldenboer. They are responsible for the teaching of the module HFL 1501. The last compulsory first year module in the Department of Jurisprudence is Introduction to Research Methodology for Law and Criminal Justice, which deals with the foundational research skills required for academic and professional legal writing. And this module is under the leadership of Professor Mabega, the lady in red, and Dr. Sono is the secondary lecturer for this module. Looking ahead, I have indicated that I will not speak to all the modules that are offered in the department. But when we're looking ahead, I wish to tell you that as you progress through your degree, you will return to this department for critical final year modules like legal philosophy. Legal philosophy will assist you with advanced critical theory and the nature of law. We also have professional ethics, which will assist you with the ethical standards required of legal practitioners, and private international law, which deals with managing legal disputes involving more than one legal jurisdiction.
Doc, your 10
Yes.
minutes has elapsed. I'll give you just 2 minutes to wrap up. Thank you.
Yes, Prof. I'm doing that. We also have service modules within the department, and these are specialized modules designed to provide legal foundational knowledge to students outside the standard Bachelor of Law degrees. And I'm referring to modules like social welfare and law, which is for students pursuing a Bachelor of Social Work. And we also have Introduction to Paralegal Studies, which is for the students who are doing diploma in law or those seeking to provide community legal advice. And we also have business practice and workplace ethics. This is a core module for diploma in law, which equips students with essential skills for employment in law, focusing on practical legal work and professional ethics. And who to contact, I wish to say for any queries regarding module content, specific subject advice, or even assignment details, you should contact your lecturers. Because I have realized that students communicate less with administrators. So you must just contact your lecturers, and they will be able to assist you with any other queries. As my parting shot, and through you, Prof. Sibanyeni, let me say, studying through comprehensive open distance e-learning requires immense discipline and resilience. So you will definitely face moments that require you to be brave, but rest assured, you are not alone. We are here as your lecturers to assist you. Thank you very much.
Thank you very much, Dr. Mahlobohwane. Indeed, discipline and resilience. And we echo those sentiments to say that students, you are not alone. Starting through Cordell, it doesn't have to be a lonely journey. We are here for you through and through up until you realize your graduation day. So with that being said, can I invite Department of Private Law, Prof. Baka?
Thank you, Prof. Simonione. I'm
Thank you.
just trying to get the to share. I'll just open. Okay, can you see my slides there?
Yes, Prof. Thank you.
Okay, thank you. I'm also just going to talk a little bit and then turn off my camera, just in case it interferes with the slides. I would like to welcome the students, especially on their journey in studying law, pursuing their studies in law. It's a very interesting field of study and very involved and sometimes challenging as well, but we are there to help them. I'm just now going to turn off my camera and then I'll share the slides. Right, so I see I've got the same challenge. My slides aren't moving. Sorry, just give me a sec.
Prof. Baka, you still
Let's
here?
try that again. Apologies. Let me,
Yeah.
I see that I'm going to have to close my PowerPoint and just start it again.
All right.
Because I don't know what happened there, but yeah, sorry about that. I'm not sharing at the moment, am I?
No.
Okay.
You're not sharing.
All right. Okay. Apologies about this.
No
A
worries, Prof.
second. Right, let's try again. Can you see my slides?
Absolutely, Prof. Yes.
All right, I'm going to presenter mode. Right, can you see it still?
Thanks.
Okay.
Yes, thank you.
Let's move on to, okay, now it's working. Sorry about that. I'll get back to the composition of the department. I think the important thing is just to ask what private law is. And if you've ever signed an agreement, borrowed something, or had a dispute with anyone, you've encountered private law. So private law is there in your everyday life. It concerns everything you do, the property we own, the responsibilities we have to each other. That is private law. So we are really involved with the day-to-day living of people and how to assist them in the law. You will also have a journey with us from your first year up till your final year in the Department of Private Law. So the modules we offer in your first year, you will have law of persons, which is then the question of what is a person and what rights do you have. And then from there, we will move on to your second year where you have family law and also the module in law of succession. Family law deals with all the matters related to family, including child law, divorce law, maintenance, and all those things. And law of succession just asks you what happens when you die. How will your estate be divided? Do you need a will? How do you draft a will? So those things will be discussed in your second year. And then in your third year, you will have 3 modules with us. The law of delict, the law of contract, and the law of property. Now, the law of delict deals with, let's start with property law. Property law just asks the question, what is property? Who owns it? And what can you do if somebody tries to take your property? So that's the principles we will teach you in the law of property. In the law of contract, that's obvious from the names. We deal with contracts. How do you draft them? What happens if a contract is not complied with? And then the other module will be the law of delict, which deals with if you've been wronged, can you claim damage, or what can you do? And then last, we have the law of enrichment and liability and estoppel in your fourth year, which deals with everything that happens if you don't have any agreement or anything to enforce it with, and how will you proceed from there. So those are the core compulsory modules that we have in the department, and the ones you'll have to take to complete your qualification. Then we also have elective modules in your final year, where we have the law of sale and lease, conveyancing and notarial practice. So those are specialization subjects within in private law. If you're interested in conveyancing, transferring property, then conveyancing is your area of expertise, and notarial practice deals with certification of documents. So those are the elective modules that we offer. The department's got 8 professors, 4 associate professors, 11 lecturers, and 12 senior lecturers to assist you with the process. You can get the link to the department website is there. And if you have any, as we've already said, queries relating to the specific module, you can contact the responsible lecturer in that module, and they will deal with your query and assist you in any way they can. In my office, if you have any administrative queries, you can contact Mr. Bogo Mapokgole. She is my secretary in the office and my personal assistant, and she deals with all the queries that come in with an administrative nature in the department. I've now actually run quickly through the slides because I was a little bit rattled when I couldn't share my slides. But that is the Department of Private Law. We will be with you through the whole process of your studies from first year to final year. And if there's anything you need, you're welcome to contact the module leaders to assist you in any way they can. And thank you, and good luck with your journey ahead. That is all I have.
Thank you so much, Prof. I think you have shifted the goalpost, and those following you, they must follow. So thank you so much. That was sentiment and straight to the point. It has eventuated that students tend not to follow the protocols. You know, there are instances where students is having a dispute. Instead of writing to a module leader, to a COD, if the matter is not resolved, then the school director all the way to Dinari. You have some students writing directly to the VC. You know, so students take note. You must follow that protocol. If one level is unable to solve your dispute, you move to a next level, that is a COD. And if that is not materializing, it moves to a director all the way to a dinner if the dispute was unable to be resolved. Thank you so much, Prof. Barker. I will now invite Dr. Ndlazi, COD, Department of Public, Constitutional, and International Law. Doc, your 10 minutes, it's now. Thank you so much.
Thank you very much, Session Chair. Good morning, afternoon rather. Good afternoon, Professor Sibanyoni. Thank you very much. And good afternoon to all the colleagues from the College of Law, as well as our esteemed guests, our students, in whatever journey you are in this morning or this afternoon. I bid you a very good morning. So I am Dr. Sigelela Ndlazi. I'm the acting chair of the Public, Constitutional and International Law Department at UNISA's College of Law. And I will be taking you through our presentation. Chair, you'll just let me know when you are able to see a visual.
Okay. Yeah. There you are.
Perfect. Let me just put it in presentation mode. I'm hoping that the technical glitches my colleagues experienced, I will be spared from. Chair, do you have sight?
I have sight. Oh, you are spared. You are spared.
I'm spared. I'm spared. I'm favored this afternoon. Students, I'm going to call you colleagues session because ideally you are working to become our colleagues in law. Your work, your study, and your educational career will lead you ultimately one day to forming part of this very prestigious profession that we're all a part in whatever capacity. But first, let me give you what the essence of public law is. Public law is crucial because it regulates the relationship between state and individuals, ensuring government's accountability, protecting fundamental rights, and maintaining order through constitutional, administrative, and criminal law. It prevents the abuse of power, governs public services like health and education, and provides mechanisms for citizens to challenge state actions. So I think perfectly on the heels of Prof. Barker's department's presentation, where private law was between two subjects, two human subjects, public law has got a government and human relationship that adds the personality there too. The modules we have in the department fit under the umbrella of public, constitutional, and international law. We will be interfacing with you as a department largely in your second year and in your final year. In the second year, you would be registering for administrative law, constitutional law, fundamental rights, African customary law, and interpretation of statutes. Before I move on, Chair, let me just contextualize these modules just for the benefit of our colleagues this afternoon. These modules are very substantive and theoretical in nature. The ability and the muscle to really fare well in these modules will have to take into account how well you can reason, how well you can critically reflect, how well you can interpret the law, how well you can criticize, and how well you can form a conclusion. So this perhaps cohort of modules challenges you to really apply your mind as opposed to merely just introducing you to a foundational, almost rudimentary context to the law. So in the fourth year modules, you would have international law, advanced indigenous law, and as electives, you would have environmental law, international human rights, as well as education law. I don't need to also explain that these are fourth year modules, exit level modules. So again, you would have to be able to critically reason, analyze, interpret, and apply facts to, the law to the facts so as to achieve a sound and academic conclusion. So the modules in the department also stretch to the LLM and LLD qualifications. We have the Masters of Laws in Constitutional and International Law, Master of Laws in Human Rights Law, a very popular one, Master of Laws in International Economic Law. We also have a doctoral program, which is an umbrella program, which is called the Public, Constitutional, and International Law Doctor of Laws. And under this umbrella program, you would be eligible to study towards public, constitutional, and international law streams or avenues of law. This is a research-based thesis, of course, typically 72 months. And the department, of course, covers public law, admin law, constitutional law, human rights, international law, and statutory interpretation. I won't delve much into the admission requirements because, of course, an LLM degree or an NQF level with the focus on related disciplines would be a prerequisite to enter into this qualification. The academic staff and support in the department, of course, yours truly as the acting chair. I've got two professors in the department and my associate professors, Professor Lee Stone, Professor Paul Mudau, Professor Lindelwa Mhlongo. I've got senior lecturers as well, Dr. Kutia, Dr. Tlamini Ndwandwe, Dr. Lifinya Mutsikari, Advocate Makama, Ms. Muwoki, Advocate Mutsumi, Dr. Mpia, Mr. Ndo, as well as Mr. Salelo. Again, you'll be interfacing with these names as you gradually make your way through the LLB curriculum. Under the lecturer category, we have Mrs. Bafo, Mr. Liputu, as well as Mr. Mabala. We also have postdoctoral research fellows, which perhaps could even be an aspiration of yours in the long term. After you graduate your undergraduate degree, register for a master's and hopefully graduate very well, and register for your PhD and graduate well there. You would be eligible to be appointed as a postdoctoral research fellow alongside Dr. Laverick, Dr. Ndone, Dr. Makwaya, as well as Dr. Osman. In terms of admin staff, we've got Ms. Matlala, who handles the higher degrees. We've got Ms. Tanya Puerta, who handles our journals. In the department, we've got 3 journals, very popular, internationally accredited journals that draw a wide audience and very multi-intra and transdisciplinary submissions in nature. We have Mrs. Sinona, who is my personal assistant in the office of the chair, as well as Mr. Simelane, the departmental administrator, as well as Ms. Moropiane, who's also a member of our support. You will also be interfacing, especially when you register for your master's or your doctorate degree in my department, you would definitely interface with Mr. Zungu, who forms part of the higher degrees committee, who assists with the allocation of supervisors. The link to our departmental website and important information is on this page. Please don't worry, these slides will be furnished to you, so you can just have access to those links. In terms of access, who to access in the department, please email Mr. Ayanda Simelane. The email is attached, as well as Mr. Smapula Sinona the email is attached. Very importantly, however, for module-related queries, first consult the tutorial letter. And if your query is still not responded to in the tutorial letter, you may contact the module leader. We have seen this time and time again dealing with students, that when we get queries from students, the language and the formality really lacks. And you always have to remind yourself that you are aspiring professionals, formal professionals within the legal fraternity. Please employ formality and respect when you make these queries. Do not address your module leaders by name. Don't say, hi, how are you, all in one line. I just need help with this. That's very informal, and that's really not respectful to the occasion. So please apply formality and respect when you make these queries, as you would one day when you address your opposing counsel in courts, or your colleagues in the hallway, or even a judge before whom you are appearing. I would like to offer you some tips for your legal career. If you registered for the LLB because you did not get accepted in any other qualification, you are in trouble, because, surprise, surprise, it is a very reading intensive qualification. You have to read and then read some more. Attend your classes. There are classes arranged, and the arrangements and times and links to your classes are posted all over the Moodle website, and the class recordings are posted as well. Ask questions. You have to deliberate with your lecturers, because that's how we really calibrate whether our teaching methods, pedagogically speaking, as well as even the content, is really resonating with the students. And of course, you would have to read some more after you receive your response. AI use. I know we are living in the digital age where everything is governed by AI. And you know what they say? Your job is not going to be taken by AI, but your job is going to be taken by someone who can use AI. Let me warn you, though, there's a caveat. This particular profession, the legal profession, is built on ethics, formality, and the respect of the court. I don't need to go into extensive detail about how many cases we've seen in the news where lawyers and advocates even have been found in contempt by judges for using AI in the drafting of heads of arguments. That can get you in very serious trouble. And actually, your client would be eligible to sue you for damages as well. So that's an even bigger layer of troubles. You have to master your time management. As Codel students, you often struggle, not because of the difficulty, but because of poor time structure. I see Sachin Share is back. Let me quickly run through. Learn how to read the law, not just how to study it. Law is not about memorizing. It is about understanding and applying principles. When you read, always identify the key facts, the legal issue, the rule of law, apply all of that and reach a conclusion. This is the Farrock method. Every single law student ought to know what the Farrock method is and how to use it. And as well as thinking long term, you are building legal thinking. Don't just aim to pass, aim to think like a legal practitioner. Link concepts in between the modules. And this is a very important one if you'd like to one day go to your master's and doctorate aspirations or levels. You have to pay attention to South African legal developments and constitutional issues, and you have to read beyond your study material very occasionally. Chair, if I, through your grace, I've got one more tip I would like to give to our colleagues this morning. And I would like to see if this link is going to lead us to where I would like it to go. Thank you very much, Chair. Those notes and advices are very applicable to your legal career and to your study journey. You have to believe in yourself. Many people will criticize you. There's a lot of burden on your shoulders, perhaps from the community, socially, familiarly. You have to find a way to rise above those fears and those frustrations and really find the fortitude from within to really garner the strength and the courage to make it in this career. With that, I would like to say very good luck and thank you to all of the colleagues who came here this morning.
Asante sana, asante. Thank you so much, Dr. Njazi. One word from me, ayikho inkomo yobuthongo. I don't know when you translate that, but as we have seen from your last slide, to me translate as ayikho inkomo yobuthongo, hard work and dedication, it is the key. Thank you so much for the tips. Yes, read, and read some more, students, because of your life depends on that. Time management is very crucial as you are studying within the Cordell. So the discipline and time management is very, very important. Use AI within the ethics framework. Think long term, of course, and I like the fact that Dr. Njazi spoke about something that goes a long way, that is respect. You know, be formal in your communique, be sincere, be humility in all your communique, and address people respectfully as you would want intent to be respected. And of course, tutorial letters are your first stop. Do not ask something that is in your tutorial letter. Thank you so much, Dr. Njazi, for that. And now we move on to the second theme, understanding law at UNISA, studying in a Cordell environment. I would like to invite Dr. Richard Shea, as a senior lecturer in the Mercantile Department. He will be speaking to us about how legal study differs from other disciplines, legal reasoning and case analysis, also legal reasoning and statute interpretation. Doc, over to you. You have 20 minutes.
Thank you, Chair. I have 20 minutes, as you say, and I have a lot to get through, so welcome. I'm going to get right into it. My name is Richard Shea. I'm going to be speaking to you about legal study, legal reasoning, and statutory interpretation. So by the end of this, I hope that you'll understand three main things: how legal study differs from other professions, the legal reasoning and case analysis approaches that we advise you take, and just a little bit about statutory interpretation. So as an opening provocation, I'm going to draw from a famous legal philosopher called Lon Fuller, who in 1958 set out this interesting question. Let's say you have a statute, a piece of legislation that prohibits vehicles in the park. Now you have to determine in each specific case whether something qualifies as a vehicle. Would a child's pedal car, for example, qualify as a vehicle? Perhaps not if there's no engine. Would an ambulance responding to an emergency, and would that rule apply to that ambulance in that emergency? Or what about a war memorial tank on a permanent plinth? So it's not even moving, but it is stationed within the park. Are any or all of these vehicles for purposes of the statute? And the point is that there is no single correct answer. There are only defensible arguments, and that is ultimately the fundamental nature of legal study, is legal reasoning and thinking about what we are trying to achieve. So in part one, we're going to look at the epistemological shift, which basically just means how do you know? What is authority? What is knowledge? How do you determine what the law is? The core shift that you're going to have to deal with, on the left of the screen, you can see from every other discipline, you have right answers that exist. If you are in mathematics or computer programming or science, there are typically right answers that exist and that you can find given the correct methodology. You're often asked to memorize and reproduce this, and authority is expertise. In other words, the textbooks that you're reading and the lecturers that are presenting it to you, those are your sources of authority. This might be familiar to you from school if you're just joining us now straight out of school. That is often the epistemological approach that is taken there. In this context, knowledge is usually stable, so it's not ever changing. It's not something that you need to verify all the time. And when you are assessed on it, it's usually in a seated, venue-based exam type of situation where you're not allowed to speak to anyone, not allowed any kind of study resources with you, and the assessment ultimately tests your recall. Whereas with legal study, there are defensible answers that you need to actually go and construct yourself. These are not things that you find out there in the wild of the library stacks. This is something that you need to create yourself. And you do that by analyzing the source materials, applying those source materials to the facts before you, and then arguing one way or the other. The authority in this case is what we call primary sources in law, which produce or rather hold authoritative rules of law. So this is where you find your legal rules in depending on whether you're working with statute or with case law, because we have a hybrid legal system. You can also be finding authority in precedent, and that becomes even more challenging to determine what is precedential, what is authoritative. And because law changes constantly every month, some aspect of law changes every time a court develops the common law, the law changes, for example. It is slightly more unsure, I suppose, of how to exactly determine what the law is and what to do when it conflicts with another body of law which also seems authoritative or is contested. So is it even authoritative at all? So in legal study, we will be testing your reasoning instead of your recall. In law, you typically don't just rely on your textbooks and your lecturers. You need to go and find the primary authority yourself and then argue it on the basis of your understanding of the secondary sources as well. In primary authorities, we mean binding sources, which are legislation enacted by the Parliament or decided cases from courts of appropriate jurisdiction. Of course, legislation is a catch-all term there for things like regulations and other forms of parliamentary authority. But also hierarchy matters. So certain courts on certain legal questions do outweigh other courts. In all constitutional matters, the Constitutional Court is the final court, the court that has the final say in the matter. Then below that, you have the Supreme Court of Appeal and then high courts. But the high courts themselves are not necessarily binding on other high courts. So there's a hierarchy that actually matters here in terms of what is authoritative and what is not. Because you need to be able to distinguish what is a binding precedent, that which a court actually held, versus a persuasive precedent, where a court wasn't dealing with the legal question directly, or perhaps it was, but that legal question is not exactly relevant to the facts before you that you're busy arguing. So in this instance, you should not be grounding your legal argument in opinion or in common sense or general knowledge or anything like that. You need to tell us which source says what and how is that relevant to this particular case. When we assess you, to assess rather your level of understanding of the particular module content, we are not looking for you to recall outcomes, especially given the Codel environment. Recalling means nothing really. It just means that you have the answer available in your working memory. It doesn't tell us that you can use it at all profitably. So what we are looking for is that you know how to reason with that, and that is ultimately what your law degree is going to be about. The statement, for example, that in a particular case, the plaintiff won, that does not help us. That does not help anyone understand what that case was about, what the proposition that case stands for is, or how we can apply it to the present scenario. A much better explanation would be applying the ratio in Minister of Police versus Mbelini. The court held that, this and that and the other, and then you relate that to the present facts. This principle applies because, so you are showing us the legal reasoning behind what you're saying. This is known as the ratio decidendi of the court. In other words, what the court decided to be binding on the particular legal question before it. and why it said that, on what principle. This is a standard component of common law reasoning, which our courts apply even in the democratic constitutional era. So the reading load and the cognitive demand of that reading load is going to probably be quite a step up from anything you've done before. This has been alluded to, but let's just say we hope you have not fallen into this course as a last resort, because then you're in for a bad time. Because what you actually need to be doing here is reading a lot of material in order to understand how legal reasoning applies. And you can't get that from short case summaries or AI synopsis of a particular legal instrument, or even just reading the textbooks. Even if you have the prescribed textbook and just reading that, you're not going to fully understand how the law thinks in the institutional capacity that is the parliament as legislature, our courts, and the executive. So a judgment, when you do start reading case law, requires active analysis across at least 5 different layers. There's the procedural history, in other words, what happened up to this point, what have previous forums decided, whether courts or other types of forums, and what has led these parties to this particular forum that is this court. Then you're looking at the facts, what has actually happened. There are the legal questions, what the court must decide, in other words. And then there's reasoning and decision. And we're going to work with the FIRAC method in just a moment. But the point to remember here is that you should be reading actively. You need to actually actively interrogate your own understanding while you're undertaking the learning activities. That's the only way that you're ever going to actually start grappling with the material, because if you just read something over and think, okay, I got that, I understood it, that's not actually dealing with the material in the way that, in the active sense that we require of you. So please don't read passively, engage your sources. Moving on to part 2, legal reasoning and case analysis. Here we're going to be discussing a court's precedent that it sets through its decisions, the ratio decidendi, the obiter dicta, and the FIRAC method of analysis. So starting with the stare decisis. The stare decisis is the common law doctrine with the Latin terminology for what previous courts have done. And it's important to just note, we're not going to be dealing with it in any detail here, but what a court says is not always going to be binding. It's not always going to set a precedent. So the first level of your analysis of case law is understanding what that particular decision, what that court's judgment sets a precedent on. What is the legal question exactly, and what is it not? So the binding precedent, once you have identified, it must be followed by the same court and by lower courts. And the Constitutional Court decisions, of course, for that reason, bind all courts in the country. You have persuasive precedent as well, which is useful to courts. It helps them to supplement and develop their own legal reasoning to the particular facts of the matter, to the particular legal question that they're confronted with, but it is not binding. In other words, they are not bound by legal custom to follow it and to implement it. So here you have, of course, obiter dicta, which could be persuasive precedent, as well as decisions of foreign courts and academic commentary. Academic commentary, as much as we may hope and pray that it will influence a court one way or another, is ultimately always going to be a secondary source, and it can persuade a court that the correct interpretation of a statutory provision or the correct reading of a particular precedential judgment is the correct way. And that's the kind of contribution, among others, that we're trying to make to the development of law in this country. But academic work is never in itself binding precedent. So, as noted here, courts may apply, distinguish, or very rarely depart from precedent, and they're allowed to do that if the precedent is clearly incorrect, or if the intervening law has changed, or similar reasons. But this requires judgment, and that is ultimately what your legal education, starting here at UNISA, is all about, and then following you as a lifelong engagement with law and legal reasoning throughout your career. So looking at the ratio decidendi and the obiter dicta, the ratio decidendi is basically that part of the court's judgment, the court's decision that is binding. So it tells you which particular principle this decision is resting on, if it is a common law principle, for example, and how it has decided on these facts. So what the legal question was here on these facts. And this is exactly what binds future courts. This is what sets the binding precedent, the primary authority for future courts. It's extracted from the legal reasoning. It's not announced as a label. You're not going to find a heading in your court judgments that say, here is the ratio decidendi. Similarly with obiter dicta, these are remarks that are made during the course of the legal reasoning in a kind of by the way manner. So they're not binding and they can be persuasive to other courts if they are sufficiently, I should say, in themselves compelling. And in that way could be influential, but they are legal remarks made that do not relate specifically to the legal question that the court was dealing with. So you must always be looking to extract the operative legal principle from the body of the reasoning of the decisions that you are reading. The most common error that we see with students using case law is treating obiter as if it is binding. So just looking at a judgment and finding a sentence and thinking, well, this is a good authority for the proposition that I want to argue, so I'm going to use it. That discards entirely the fundamental dichotomy between ratio decidendi and the obiter dicta. When you go to structure your own legal argument, so for example, when we present you with a scenario, a set of facts, and require you to argue one way or another, as Dr. Ndlati has taken us through, the Farrak method is a very useful structure to follow in answering those kinds of questions. And this asks, what are the key legal facts? What is the precise legal question to be resolved? What does the law actually say? So you go and trace it to the statute or the case. And if it is a common law principle, it is not very common anymore to go and find the original authority for it. You typically find common law principle through case law, but it is possible to go and look up the actual source of that rule. Then how does the rule apply to these specific facts? And this is what we're actually looking for, is how do you apply the rules that you've identified as being applicable here? What do you do with those rules? Then your conclusion, how do you actually resolve this legal issue? Because remember, in every set of facts, there are various legal questions, and that would suggest that there are various legal answers to those questions. The most common error here probably is that students tell us too much about the rule. They'll just tell us everything that the statute says, as if that shows us their depth of learning and understanding of that particular rule. We can see that you've clearly identified this as being applicable, but that's about where that ends. So don't give us too little application. Always focus on the application of applying the legal rules once you have identified them. Make sure that that takes the gist of your submission. So when you are approaching a judgment, a decision, you are firstly analyzing the case is not the same as just reading a case. So your 5 steps that we went through a bit earlier, your procedural history of facts, legal question, reasoning, and decision would make a very useful very useful structure and approach to determining what is the ratio, what is the obiter, how can I actually use this case, how can I understand it in the broader context of being a source of law on certain propositions in the South African legal system, and how does it relate to other cases that do similar work on similar legal questions. Finally, we're going to look very briefly at statutory interpretation. There are typically in South Africa 3 broad approaches to statutory interpretation, looking at the text, the purpose and context kind of together, and then the constitutional prism as it's known. So the starting point is conventionally the textual approach, also called the kind of literal approach, because you just ask, what does the text actually literally say? What does its literal construction of that meaning produce? Sometimes this is straightforward and clear enough, but sometimes it's ambiguous. And you need to actually go and study further, well, what are these ambiguities? How many ways could we construe this particular statutory provision? Going back to the no vehicles in the park hypothetical. So as you may remember, we had a few examples there that weren't necessarily clear. If you had a lot more context around this, that might become clear. For example, is this park a nature conservation and they don't want engines, in which case a child's push bike or car might be fine, or a war memorial tank that is not functional might be fine, but an ambulance might still present a problem. So for borderline cases where there are ambiguities, where there are ways that you can argue one way and the other, this doesn't exactly resolve the question. So the literal approach is always only a starting point. Please never treat the literal interpretation that is the product of the textual approach as the endpoint. Moving on to purposive interpretation, this is where you go slightly beyond the literal meaning of the words and you ask, well, what was this particular statutory provision designed to achieve? This can typically be drawn from the context, whether it's within the particular statute itself. Often you would have a preamble or postamble or a memorandum of objectives that would give you this very useful, valuable context for your interpretation, which would then feed into the meaning that you give those words in their surrounding context. And then you can also look at surrounding statutory instruments, because as you'll see, law is a densely woven, interlayered mesh of different statutory instruments and common law rules. And often from those other statutory instruments, you can draw purpose and context. And then, of course, you must always draw purpose from your constitutional imperatives, whether these are in the form of rights or values or constitutional objectives even. Those are all very, very important purposive signifiers, and they're different to constitutional interpretation in itself. So purpose is always in the background. Remember this, even in very routine matters, there is always purpose that is relevant to the interpretation of the statute. Finally, looking at the constitutional prism, courts have, for the past 20-something years, been reading interpretation through the prism of the Bill of Rights. And if you haven't dealt with the Bill of Rights in any meaningful respect yet, it comprises Chapter 2 of the Constitution of the Republic of South Africa and is the normative substance of the Constitution. For the most part, all other chapters in the Constitution give institutional clarity and perhaps some direction to how the state should be run. But the Bill of Rights is where the right to equality, the right to dignity, the right to life, all of these rights that you've heard of in the normative context, in other words, they have substance of what needs to be delivered to people in terms of the defensive and assertive mechanisms of those rights. That's where they live. So there are various statutory interpretive techniques that courts use, such as reading in, reading down. They can read up and down as well. But reading down is a technique to avoid constitutional invalidity. So, for example, if you have a piece of legislation that is clearly in contravention of one of the constitutional rights, then you can adopt a meaning of that statutory provision that produces a different outcome. In other words, you give it a different content in order to avoid the conflict with that constitutional provision. And in this way, you kind of change the meaning of that law in order for it to be more cohabitational, shall we say, with the constitutional scheme of law. Reading in, sometimes you need to fix deficient provisions, and then courts need to literally act as a legislature in a very limited capacity and add words to a statutory instrument in order for it to be saved from constitutional invalidity. You'll learn about all of this in the modules ahead in your legal studies career. The important thing to notice here is that interpretation of statute is never straightforward. It's never plain and simple. It's never just what the actual thing says on the face of it. And you will encounter all of these in every one of your CLAW modules during your studies. So when you do encounter the substantive, right, I'm on my last slide just here. When you do encounter these interpretive difficulties in each of your modules, you can start in this kind of context, but remember that the constitutional context is always the most important. We live under the doctrine of constitutional supremacy, and for that reason, we need to take the biggest heed of the constitutional context. Then you need to start thinking about legal reasoning as a craft skill, as something that you develop yourself, and it improves with deliberate practice, not with passive engagement. So returning to the example of the no vehicles in the park, now you have a lot more tools than you did just 20 minutes ago to understand what does vehicle mean on its ordinary reading, what was the purpose of the prohibition, and does any interpretation raise a constitutional concern? These are the kinds of issues that you're going to be dealing with your legal reasoning. So please start giving assessors the structured, source-grounded arguments that they're looking for, rather than giving them what you consider to be the right answer. Thank you very much for your time.
Thank you so much, Doc, for such a thought-provoking presentation. It is clear and straightforward. It gives a contextual differentiation of what distinguishes law from other disciplines. And I think you and Dr. Ndlas, you are joined from the hip. What is echoed? It's reading and reading and more reading as a legal reasoning is a craft skill. It improves with practice, not passive reading. And of course, you alluded the fact that argument must be grounded in source, not in opinion. And for you to have those sources, you must do extensive and intensive reading. Thank you so much. With that, students, have your questions, burning questions on the presentation. Write them on the charts if you can't wait up until the Q&A session, so that we can answer those questions. Keep them coming, and Dr. Shai will be here to answer those questions. Thank you so much, Dr. Shai, for such a very pivotal presentation. I'd now like to invite Advocate Ali Leonard from a tuition and learning, student support, and engage scholarship. She will be presenting on module sequencing, credit loads, exemption application, and progression rules, understanding of prerequisites, elective modules, and core requisites. Advocate Ali, the podium is yours. You have about 15 minutes to conclude. I thank you.
Thank you very much, Chair. If you can just confirm that my presentation is visible and that it is on presentation mode.
It is on presentation mode, Ali, and I'm not going to ask you to show your face.
Thank you. Thank you from, yeah, you actually saving the students from that torture. Thank you very much, Chair. Yeah, so my job, I thoroughly enjoyed listening to Dr. Shea, and the way in which he expounded on what it means to train and to study law. I think one of the biggest takeaways from that particular presentation is, that there's the argument about getting to an answer is more important than simply simply writing down what you think is the right answer. So the thinking skill, the practice of creating and crafting these arguments is what you should focus on, as opposed to simply trying to memorize information. But that isn't actually why I need to speak to you, but it was really a good presentation. So what I need to speak to you about is something that is much more mundane, but could impact on your studies. So it's about the curriculum and how the curriculum is sequenced. and some of the matters that you need to pay attention to when you are actually registering. So to start off with my presentation, I just want to welcome you to the College of Law. We are so excited that you are joining us and that you've chosen this particular college to pursue your legal career with. And, you are joining a huge list of luminaries, that have pursued their studies, their legal studies in this particular college. So as the college, we are here to walk with you. And if you need any additional support, please feel free. So with regard to registrations, the first thing to note is that at undergraduate level, the modules that you register for are all 12 credit semester modules. This means that if a module will be offered in the first semester, and that same module will be offered in the second semester. If you are unable to register for the module in the first semester for whatever reason, you may be able to register for that module then in the second semester. And also note that the maximum number of modules that you can register for in a year is 10. But you don't have to register for 10. You know your own circumstance, you know how much time you have to devote to your studies, you know all the other commitments that you have. So when deciding how many modules to register for, please look at your own life circumstances and then make that particular decision. Now, all of the qualifications that is offered in the College of Law is on our website. And the qualifications all have what is called combination rules. So in my presentation, in blue, you'll see all qualifications. If you click on that, it's a link to the qualifications that we offer, and you can just click on the link to the qualification that you are registered for to see what the rules are. But I just want to explain some words to you. So the first word that you'll see on a curriculum is the word compulsory. And what compulsory means is it's a module that you have to do. You don't have a choice. If you don't do this module in the curriculum, you're not going to be able, the institution cannot confer the qualification on you. So all compulsory modules must be registered for. Then you'll see another term called elective. So what an elective module is it's a choice. The curriculum will indicate a number of modules, and then you may elect to register for specific modules. The curriculum will also indicate how many electives you will have, how many choices you'll be able to make. Then you'll also see in some qualifications, so in the School of Law particularly, the BCom in Law, there's something called groupings. And a grouping simply means that modules from a particular discipline are grouped together. And if you select a particular group at the lower level, you need to continue selecting that particular group in the higher levels as well. You must not mix groups. So for example, if you decide in the BCom to focus on the law stream, or the business management stream, then you need to do the business management stream in all of the levels. You cannot suddenly decide, no, in second year, you're going to move to a different stream, because even if you meet the curriculum requirements in terms of the number of modules, so you've passed the right number of modules, if you don't have the correct streams, then the qualification is not going to be conferred on you. Then, particularly in the College of Law, prerequisites are incredibly important. The college does not waive prerequisites. So when you plan registering for the curriculum, please take prerequisites into account. Now, what a prerequisite is it's a module that must be passed before the subsequent module can be registered for. So in the LLB, for example, the module LME 3701 is a prerequisite for 7 modules in the final year of the LLB. So that module, you need to make sure that you register it for it as early as possible and you pass it as early as possible so that it doesn't delay the final year of your studies. Then there's another term called a co-requisite. What a co-requisite is it's a module that must be registered with its sister module. So if, for example, in a curriculum, it says ILW 1501, and then it says co-requisite SJD 1501, it means that ILW 1501 must be registered at the same time during the same registration period as SJD 1501. And the last word that you may see on a curriculum is recommendation. And this is simply a suggestion that the college has made. It's not binding. You can choose whether to adhere to the suggestion or not, but you're not bound to that particular suggestion. Then a few other remarks around registrations. That's credit exemptions is a way in which certain students who have done previous qualifications or have certain work experience may be able to be exempted from particular modules and complete the qualification in a shorter period. So credit exemptions, you apply for a credit exemption for a particular module at registration. If, for example, you've done a qualification at another institution and you look at the content that UNISA offers and the content that you had done at the other institution, and it's similar, it's also at the same NQF level, and there are a few other requirements, then you can apply to be exempted from having to register for that module at UNISA. You can also be exempted from credits via the RPL process, but I think Ms. Lewis is going to explain in detail what that actually means. Then also just a remark around SJD 1501, the signature module in the College of Law. What a signature module is, it's just a compulsory module that every student in every undergraduate qualification in a college has to do. So our advice is to please register for SJD as early as possible, as it is a foundational module. Then also to note that not all modules are offered by the College of Law. Some modules are offered by sister colleges, and if you need any advice, if you need any support, then you actually have to go to the sister college in order to get the advice and support. Examples are, for example, PLS 1502. That module is offered by the College of Human Sciences, or FAC 1502. That module is offered by the College of Accounting Sciences. So there are few of those modules, particularly in the LLB, that are offered outside the college. Then just for students who are currently registered for a higher certificate or a diploma in law and want to articulate, for example, to the LLB, please note that there are no automatic transfers to other qualifications. If you want to register for a different qualification, you have to apply during the during the applications period. And if you are admitted to the new qualification, then you may register for it. But there isn't a system where if, for example, you register for the diploma in law and you don't want to do the diploma, but you want to do an LLB, that you get transferred from the one qualification to the other. UNISA does not have that system. And then just to, we also want to ensure that you are responded to and that you are assisted as quickly as possible. And in order to do that, you need to know who you have to contact about specific matters. So for the College of Law, all queries about admissions or registrations, please contact the Directorate of Student Admissions and Registrations at jus@unisa.ac.za. We cannot assist you from the college's side. We cannot assist you with any queries about admissions or registrations. We don't have the knowledge and we don't have the systems in order to be able to help you. So, your quickest bet and your best bet would be to contact jus@unisa.ac.za. So I said I was just going to look at the curriculum quickly, and this is the BCom in Law curriculum. If you look on the left-hand side, this is the second level, or the screenshot on the left is the second level, the screenshot of the right is the third level. On top, if you look under Group A, you'll see compulsory. So all of the modules, ADL, CRW, MNB, all of those modules are compulsory. You have to register for those modules in order to be awarded this particular qualification. Then on the right-hand side, you can see prerequisites, co-requisites and recommendations. And if you look, for example, at ADL to 601, the prerequisite for that is ILW 1501 and SJD 1501. So please make sure that you then register for ILW and SJD, pass those two modules, and then you'll be able to register for ADL to 601. Then if you look closer to the bottom, if you see FAC to 602, you'll see a co-requisite to CBC 1501. What this means is that at the same time as you register for FAC to 602, you need to register for CBC 1501. And then the last, let me just see, yeah, I just also want to just reiterate the groupings. So in the BCom in law, there are 3 different groupings that you can focus on. You can focus on financial accounting, taxation, or economics. So if at level 2, you choose to focus on financial accounting, then you have to register for specific modules in the second level, and you have to choose group B again and register for those modules at the 3rd level as well. Please don't mix those streams, because if you do mix the streams, even if you meet the maximum number of modules, you are not going to be conferred the qualification. Then I just want to speak to you quickly about the different qualifications that are offered in the School of Law. The first being the higher certificate in law. This particular qualification has 10 compulsory modules. There are no electives. And you can, the minimum period that you can complete this qualification is a year. But the maximum period is 4 years. So if you do the 10 compulsory modules, you can register for all of them in year 1. If you pass all of them in year 1, you'll be conferred the higher certificate, but you're allowed to complete this qualification in 4 years. The School of Law also has a diploma in law. It's a 360 credit qualification with 30 compulsory modules. The minimum period to complete this qualification is 3 years. The maximum period is 8 years. Then the BCom in law is also a 3-year qualification, 360 credits, 30 modules. Remember, 24 compulsory, and then the remainder are the streams. Please remember, when you're registering for the BCom, you need to choose a stream and then stick to that particular stream. And for the BCom in law, you have a maximum of 8 years to complete it, a minimum of 3 years. And then the biggest qualification in our college by far is the Bachelor of Laws degree, the LLB. It's a professional qualification, which means it has 40 modules that have to be completed. 37 of them are compulsory. There are 3 electives. And the minimum period to complete an LLB is 4 years. The maximum is 10 years. Just for the students who are completing a higher certificate and want to articulate to the LLB, remember, you need a minimum of 60% as an average in order to apply for the LLB. And also for all students, including higher certificate students, the completion of a higher certificate doesn't guarantee that you are going to be given a space in the LLB. So, try and do as well as you possibly can. It improves your chances to get into the subsequent qualification. I'm not going to touch the postgraduate qualifications. Some of the departments have spoken about it, but I just want to reiterate the dispute resolution process that Prof. Sibanyoni also spoke about. If you want your matter to be resolved as quickly as possible, then please send an email with an explanation to the module leader, explaining what had happened and the assistance that you need. If the matter cannot be resolved by the module leader, you're welcome to escalate that matter to the COD. At the COD level, this is generally where matters are resolved. In exceptional circumstances, If the COD cannot resolve the matter, or the student doesn't feel that it's resolved in their favor, then the COD can refer that matter to the director, and finally the director then refers it to the COD. The last point I just want to make is no is also an answer. Sometimes, students think that we don't want to help, but sometimes we cannot help. Because the university has particular rules, they have particular processes and procedures that as academics we have to follow, and we are then unable to assist the student because we have to comply with the rules that the institution and the framework that the institution has provided us with in order to deal with particular matters. One such example, quickly, Chair, if you can just indulge me, one such example is, for example, during the exam, a student may submit something on the Invigilator app. They submit the correct version of the script on the Invigilator app and the incorrect version of the script on My Exams. The rule is that the My Exam submission will be marked. It doesn't matter, if you write, if you try and justify it, there isn't anything that we can do, because the rule is that that particular submission on My Exams will be marked despite the fact that it's the incorrect submission. So the point I'm just trying to make is, sometimes, we try and assist as best as we can, and students may still not be satisfied with the response, but the colleagues are operating within the environment that UNISA has provided them with. So students, enjoy this journey, learn as much as you possibly can, participate in as many experiences as you possibly can, be brave. Ask questions, see if there are any opportunities that you can take during this period, because you need to ensure that you've utilized as many opportunities as UNISA can offer you to create a well-rounded graduate at the end that has those skills and has the knowledge to serve the community out there. And the college is prepared to walk this journey with you. So thanks very much, Chair.
Ali, thank you so much. Indeed, students must exploit these opportunities. They are here for them. They must exhaust these opportunities. Thank you so much for that insightful presentation, as always. And I can see some activities happening in the charts. Thank you so much, colleagues who are attempting to answer some of the questions on the charts. That's very much appreciated. And these students, it's not only serve as an orientation, but as a capacitation as well. And we are here to tell you all about the goodies that are embedded within the College of Law, within the School of Law, all the nice things that are building or going to build towards your career. With that said, I will invite Mrs. Elda Nyamanza, who's an attorney at UNISA Law Clinic. She's going to tell us all about the law clinic. She's going to provide information on legal services that are offered in a law clinic, and how you as students can partake in the activities of the law clinic, subsequently even work or make your articles at the law clinic. Elda, can I invite you to ascend the podium? Your 15 minutes has begun. Thank you so much. Are you in a platform? Elda?
Thank you. Thank you so much. I'm showing my audible now.
Yes, you are audible. Thank you so much for showing
Okay.
your face. We can now connect the face to your voice.
Thank you so much, Prof. Sibanyoni. Greetings to all the colleagues at large. and greetings to our students who are going to be our fellow colleagues in the profession. As correctly introduced, my name is Elda Nyabaza. I am a principal attorney in Polokwane Law Clinic, standing in for Ms. Shaida Mohammed, who was supposed to present. I'm also standing in for our head of law clinic, Advocate Kabo Timrota. Without further ado, may I please fly my presentation? I'm not sure if it's just give me a second. I'm not sure if it's visible on everybody's end. Thank
It's
you.
coming. There you are. There
I'm
you
not
are.
happy with the pencils popping up. I hope it won't be much of a disturbance.
Yeah.
Okay. As indicated, the UNISA Law Clinic is typically an independent professional attorney's practice, and it is recognized by its professional body, namely the Legal Practice Council. Basically, I can pause here and also clarify to say that the law clinic is more or less like a law firm. I know that there's a general confusion generally in the society or within the ambits of the community that they might somehow confuse the clinic with the medical term. So this is a law firm which is affiliated under the UNISA college as well, UNISA University. And as indicated before, we apply and receive our accreditation and certification, and therefore the rules which are applicable to us, they are generally applicable to any other practicing law firm. So there is not much entities different, save for the fact that we do not apply for the Fidelity Fund certificates because we don't handle finances. So pro bono institutions like the law clinic or the legal aid bodies, they are not allowed to handle finances. That is why we don't normally apply for the Fidelity Fund certificate. Therefore, at the end of the day, the members of the community, they are not mandated to pay any legal fees because this is a pro bono institution. So in those types of institutions, you normally find the attorneys who are empathic for the poor and also with a drive to serve the community. And in the process, also the standards of the services rendered are also of a top-notch quality. The UNISA Law Clinic, as I indicated, it falls under its head by the name of Advocate Hahutim Rodam. The head office is situated in Pretoria in Sunnyside campus. And we've got 3 additional branches, namely Polokwane, Middlebank, and Paro, which were established in 2022. The law clinic is staffed by the legal practitioners, i.e. principal attorneys and candidate legal practitioners, the legal secretaries, advocates, receptionists, and legal messengers. We also have a marketing officer and a project coordinator and legal researcher. On the reasons why the clinic exists, we have 2 primary goals, namely to offer the clinical legal education for our final LLB students with the emphasis on the development of an ability to think analytically and instilling an awareness of the practical consequences of applying the theoretical knowledge. And secondly, to deliver free legal services to the indigent members of the public in line with the guidelines of the Legal Practice Council. In terms of the services of what we do, we offer legal assistance as a service to the indigent members of the community. These are done under the control and supervision of the qualified admitted legal practitioners. I must pause to indicate that for a legal practitioner to have a candidate or training attorneys, they must have a post-admission qualification experience of more than 3 years. Most of our attorneys, they do qualify in that respect. We also assist the indigent members of the community in the following matters: divorce matters, maintenance issues, domestic violence matters, and evictions. Further civil litigation, labor matters, and some impact litigation, and some criminal matters. In some instances where we don't render or is beyond the scope, we also do not just turn the clients away. We offer advice and guidance as to how best the client can be assisted, because you may find some matters they don't necessarily need to be litigated upon. They just need to be referred perhaps like to a dispute resolution forum, which can adjudicate on the matters without the involvement of the legal practitioners. In the course of our work, we also render our legal services, which includes consultations, drafting of the letters, notices, pleadings, appearance on behalf of the clients at courts and other tribunals, i.e. the CCMA, the lower courts and the higher courts, offering of the advice and the roundtable discussions, and also the pretrial hearings and the like. As the law clinic and as per the rules of the Legal Practice Council, we cannot assist clients with the road accident fund matters, administration of deceased estates, liquidation and sequestration, conveyancing, and medical negligence claims. Like I said before, we can render legal advice in any event so that the client can be correctly guided as to where to get appropriate assistance in that regard. In terms of the people or the members who qualify to become a client in terms of our law clinic, we do what we call a means test. It means that we have to determine that indeed the services are rendered to the correct members of the community, i.e. the indigent members of the community who cannot necessarily afford legal representation in the normal scope of, day-to-day livings. And also further, we also are aware that there are some instances a person can be highly indebted. So basically, they will have to come and indicate with their income and expenditure. And if we're satisfied that indeed they do qualify, then we also check as well the merits as well. We don't just take matters, we have to check the merits. And if there is any sufficient ground to pursue the matter, and then from there on, we can proceed to assist. Our working hours, we take clients between Monday to Thursday, that is between 9 to 12:30, so that at least it will also allow enough time for the other matters, administration, and so on. So between the indicated hours, the clients are welcome to walk in any of our offices which I've indicated before. In terms of the student support and how the clinic contributes, we further provide clinical legal education to the UNISA law students through the College of Law on the Foci Plan projects. We've got the moot court, which basically is the mock judicial proceedings set up to examine a hypothetical case as well as an academic exercise. This will assist in obviously sharpening the skills of the student as they prepare into the legal profession. That's why in that setup, we normally require third-year and fourth-year students, because at least they are in a state of maturity where they'll be able to understand as to what is expected of them in that regard. And then we've got the street law, which is the training of the LLB students as well on the practical aspects of various legal topics. Then the students are mandated to present to the community members as a form of educating and empowering them. So in that instance, there is the first tier exercise. Normally, we have the second year students who partake in that, and some third year students as well, so that they'll be able to sharpen their presentation skills to the community, and at the same time, the community will benefit. So in other words, we'll be taking the law to the community. And then we have the student debate, which normally takes place like it's an annual debate. And that one is usually crafted for our entry-level students, that is the first year students, second year students, so that they develop their writing skills, presentation skills, and argumentation skills. So they'll be normally given a topic in which the test or the basic test of their skills will be tested in that regard, so that at least they will get a picture on how they should be able to craft their arguments in the legal setup. And then we have the practical legal skills. This provide it's a extra curriculum education in the specific focus on the application of the theory. On this particular foci project, we strictly want the fourth year students. The reason being, these are the students who are ready to actually get into the profession, i.e. become candidate legal practitioners, and therefore be able to become also practitioners thereafter. So we've got members of the profession who will come in and teach on the aspects like ethics, for example, how to prepare if you've got a matter, how you should conduct yourself, as a legal practitioner, how the society views you. So these are the kind of the skills one will need, which you will use in your lifetime set up as a legal practitioner. So therefore, that is the reason why we basically focus on the final year students, because they are almost ready into the profession. Then we offer the practical vocational training to our LLB graduates for a period of 2 years. So basically, when there are vacant posts, we advertise, and the UNISA LLB graduate apply as well. And upon being successful, they enter into a registered vocational training under the legal practice council of the relevant place, i.e. if you are in Gauteng, it should be normally the legal practice council in Pretoria. And that's an example. So at the end of the day, that is where the student, you are like an attorney. So those skills which were taught from your academia as well as the foci projects and so on, you are now actually in a position to consult with the client, obviously under the guidance and supervision of the practicing principal attorneys. Then you should be able to prepare your matter, handle your file from the start up to the finality. So this is now how you are basically, you get sharpened in that aspect. I also want to pause and add as well that in doing your practical vocational training, there is what we call the law school. It's a practical legal school, which is mandatory, which means that one has to also ensure that they also register for that training law school. There are different periods. Usually there's one for 6 months. Then there are some shorter periods which are governed in terms of the length of your articles. So those are the criteria which are needed, and in addition to writing your board exams, which will make you qualify as an admitted attorney at the end of the day. So going back to practical vocational training scope, the candidates, as I explained, are given files to work from the beginning and opportunity to consult, so draft documents, as I've explained earlier on. We currently have 14 candidate legal practitioners who serve their training and thereafter will be admitted to practice, as I've explained earlier on the procedure which takes place. For any further information about the law clinic, the foci projects, and so on, you may contact our head office in Pretoria, as I've earlier indicated. We've got our Facebook, UNISA Law Clinic. We've got our Instagram, UNISA Law Clinic. We have an email, lawclinic at unisa.ac.za, YouTube, UNISA Law Clinic, Twitter, UNISA Law Clinic. So with that, I believe that the information will be sufficient for you to be inducted as to what we are all about. With that, I thank you and I wish you all the best of luck in your profession. Thank you.
Thank you so much, Mrs. Elder. The law clinic is doing wonders. The law clinic, have no words to describe. It's remarkable. I hope students, you gain somewhat knowledge about what the law clinic is all about. and its offering, and how you can take part as Ms. Elda was presenting, and more so at your third and fourth year, and how you can actually partake as well when you're doing your second year. Thank you so much, Ms. Elda, for presenting on the law clinic. Now, can I ask Mel Lewis to tell us about RPL, recognition of prior learning? Mel Lewis, you have 15 minutes to conclude your presentation. When you see my face, just know that your time it's up. Mel Lewis, you can come through.
Thank you, Chair. Greetings to all the colleagues and our students. My name is Muhle Lewis. I'm an RPL coordinator in the College of Law. Let me share. Is my screen visible?
Yes. Can you put on slide mode, please?
Oh, what happened?
You cancel them out.
Sorry about that. My name is Muhle Lewis. I'm here to give information about RPL, which is recognition of prior learning. It's one of the programs that.
Mel Lewis, can I ask you to put your slide on presentation mode?
Okay.
Merci. Bye, thank you.
Thank you. Recognition of prior learning, it's a process where we recognize competence, knowledge, relevant skills that were acquired outside the educational training. A person will acquire these skills at the workplace, informal learning, in the community by doing community engagement, and it doesn't matter when and how the skills were acquired. We've got two ways of RPL, which is RPL for credit module and RPL for direct access. RPL for credit modules, it's for those students who are already registered with UNISA, who during their studies, when they study, they recognize that some of the modules in the curriculum align with what they are doing in their workplace. Some if you have been working in the legal department, then you recognize that some of the modules, they go hand in hand with the curriculum or the module content. You are welcome to apply for those modules to be credited through using your working experience. And you can be credited up until 50% of the curriculum of the modules. Let's say, for instance, LLB has got 40 modules. You can apply up until 20 modules. Then if it happens that we grant you all those 20 modules, you'll be left with then 20 modules to study. It helps you to fast track your completion of your qualification. Instead of you doing your LLB in 4 to 5 years, you can complete your qualification in 2 years or 3 years. Then we've got RPL for direct access. This one is where we assist students who doesn't meet the admission requirement. But unfortunately, in the School of Law, we don't accept students for access into a qualification due to the legal law society professional body which regulates the qualification. It prohibits us to do that. So we don't accept students. If you apply and you don't meet the admission requirement, unfortunately, RPL cannot be able to assist you to get into UNISA using your experience. How can you apply for module credit? You need to be 23 years of age and above, and you need to have 3 years of working experience, and your experience should be aligned to each and every module that you need to apply for. You'll have, if you apply for 5-10 modules, you'll have to give 10 motivation. Each and every module must accompanied by its own motivation or portfolio, telling us what do you feel that your experience meet the learning outcomes of each and every modules. And you can be credited up until 50% of the curriculum, and you need to be a UNISA registered student for you to qualify for RPL. This one is for access into qualification. Unfortunately, with LLB, we don't have, but we do have access for masters and doctoral through the RPL process. These are the required documents that you need to submit when you apply for RPL. You firstly send your inquiry to us via email, then we will send you the RPL application form. You will fill that application form and attach all these documents that are mentioned here. RPL is not free of charge. There are fees aligned with RPL. If for you to apply for RPL for module credits, you'll have to pay 220, which we charge per application, not per module. It doesn't matter how many modules you apply for, you pay for application, not per module. Access for masters into qualification, because you can apply through the RPL doing the LLM, is 1,750, and the handling fee is non-refundable. If you apply for modules and you get rejected, you don't get your money back. This is our contact details. RPL consists of 2 admin staff, which is me, myself, and we have our RPL administrator. This is our email address. Thank you. I'm done.
Thank you so much, Louise. Much appreciated. You know, we know your dedication to the cause of RPL and how you go out your way in terms of rendering these services to our stakeholders. That's very much, and we are proud to say that there are students who graduated through RPL. And I must say that I have one master student that graduated last year through the RPL. Thank you so much, Mayor Louise. That was very short and sweet. Now, colleagues, we move to another theme, that is academic integrity and professional ethics in law. Very, very pivotal theme as well. May I invite Prof. Khayer on a podium to talk to us about plagiarism examples specific to legal writing, e.g. case citation, use of legislation, also to attach on approach to assessment of legal writing. Prof. Khayer, you're welcome.
Good afternoon, everybody.
Good afternoon.
My name is Sunal Khayer. I'm an associate professor in the Mercantile Law Department, and I teach copyright law most of the time. But copyright law and plagiarism is not the same thing. So, plagiarism is ethics, and that relates to all modules and to all fields. Just one moment, I'm just struggling to get my screen moving. There we are. Okay, so if we look at academic integrity at a UNISA-wide level, how the university manages this is through policies. So the most relevant policies are the academic integrity policy and the copyright infringement and plagiarism policy. Soon we will also have artificial intelligence guidelines and an artificial intelligence policy. And I'm sure that by now all of you have also done the compulsory academic integrity course for this year. And in that course, UNISA tries to make these policies easier to understand. So there are videos and examples and scenarios and quizzes to help you digest the policies. But generally, they are not that difficult, actually, the policies. Maybe try and read them. I think you will be surprised. They are not that hard to follow, especially as you are law students. Then, in the College of Law, we have many originality checkers, like Moodle proctoring, the Invigilator app, Turnitin, and then, of course, don't underestimate your markers. Your lecturers mark many assessments. So we do see plagiarism, even sometimes if the detectors don't pick it up, we can see it. So don't take any chances. What I can advise is that please, to make sure that you attend training well before the assignment or the exam. So let's say the Invigilator app is used in your exam, that you know how to use the Invigilator app weeks before the exam already, so that there's no last minute stress. Invigilator app is like if you are in a writing exam in a venue at another institution, there would be somebody at the venue watching you, walking around in the venue, who's called the Invigilator. And the Invigilator app basically makes your cell phone do the same thing. So your cell phone watches you and listens to you to make sure that you don't cheat in the exam. And then Turnitin. There it's important to understand things like your submission must be in the right PDF format, and you are not allowed to submit a written assignment because then Turnitin can't read it and it will be disqualified. So even though the Turnitin process is automatic, you just submit and then the Turnitin report gets created automatic. There are these small things that you have to know about. So different modules use different checkers. So make sure which ones are used for the modules that you are busy with and attend the training as soon as possible. Okay, so here are a few examples of plagiarism specific to legal writing. Now, what would that look like? And before we go through the examples, I just want to give a general, very basic, let's call it a definition of plagiarism. Plagiarism is to pretend that something is your own original work. So there's this element of misrepresentation or fraud, where a piece of work was created by your husband or your sister or your roommate or the author of a textbook where you copied from, or it was created by AI, and now you pretend that that is your own work. That is what plagiarism is. So let's take a few examples. Plagiarism can be where a submission substantially corresponds with existing sources. The sources are not acknowledged, and the non-original parts are not demarcated by quotation marks. Okay, take that in. So, general rule is if you acknowledge, if you cite, if you are transparent, then it basically cannot be plagiarism because there's no pretension. You're not pretending that something is your own because you say where you got it. And it's not enough to just put in that in-text reference or the footnote. If you took words directly, if you copy word for word, you also have to use the quotation marks. The second example. Plagiarism can be where a submission is substantially similar to at least one other student's submission in ways that cannot be explained by them engaging with the same study material. So you may think you are buying an exam script from a ghostwriter who probably anyway uses AI to create it, and he promises you this is for you only. And instead of getting your pass mark, you actually get a disciplinary result because your submission was substantially similar to 20 other people's. Okay, so it's things like that. It's not always where you work together or where you copied from one person. It's also just cheating generally comes out like this, and this is in plagiarism because it's not your own work. Where your submission contains substantial likely AI-generated text, or even worse, where your submission contains AI-generated text and where you used AI to cover that up. Okay. That is even worse plagiarism. And plagiarism is also where your work contains exhaustive, where it contains resources that do not exist. Or you're referring to something that does exist, but it's not relevant. So maybe you are referring to one of your prescribed cases, but the paragraph you are referring to has nothing to do with what you are discussing. So you want to make it look as if you went through the trouble to look at your prescribed cases, but actually you just put one of the case names in there with a paragraph. Okay, that is, you are deceiving the marker. And if you get caught out, it's plagiarism, it's cheating, and you will be in trouble. And maybe at this point, I think this can be a good place, seeing that we are emphasizing citation and acknowledgement here, to say something about the use of artificial intelligence. So, as I said, we're waiting for those guidelines. In the meantime, what I can advise is in the academic context, if you use AI, you have to declare that you used it and how you used it. So exactly how you used it. Now, let's say you do that. You used AI and you say, exactly, this is the prompt that I used. I used this AI. This is what it gave me. This is how I changed it. And you explain so that the marker can see the difference. What is your own contribution? Let's say you do all of that by the book. You do it right. Then, that will not be a plagiarism because there's no pretension. There's no misrepresentation. You are transparent. But if the rules for that assessment said that you may not use AI, then you will be disqualified. You will also get 0 So it's not plagiarism, but the rule said you may not, and you did. So then you also get 0, even though it's not plagiarism. So that is important to know. Make sure that you know what the, even if in some other training, it tells you this is the right use of AI. If you may not do it for an assessment, you may not do it. It's like somebody can be the fastest in the 100 meters in the world. If he steps out of his lane, he's disqualified. This is the same. If you may not use AI and you use it, then you're disqualified, you get 0, even though it's not plagiarism if you were transparent. And then another thing that's, I think, also important to note. So let's say you're fully transparent, you say how you use the AI, and you may use it, but your own input is so little. For example, you explain in an addendum to your assignment that you just took the assignment question, you gave it to ChatGPT as the prompt, you took the answer, you inserted inverted commas, and this is now your giant footnote, and you submit that assignment. You are fully transparent, so it is not plagiarism. Let's say there was not a rule against it, or it was not prohibited. But still, how many marks can you earn for that? Maybe half a mark out of 50 for knowing that ChatGPT is AI that you can use. We can't mark that submission. We can't mark that essay because it's not your own work, and it is your work and skills that are being assessed. So can you see how these things are interwoven? Sometimes, even though it's not plagiarism, it is still not your own work, and you cannot get marks for it, or it was not allowed to use AI, for example. So what I want to urge you today is to watch out for announcements about training events. I know you get a lot of correspondence from UNISA, many emails and other types of messages. But in between all of these messages, look out for the ones that will empower you to submit excellent own work that is transparently referenced in the prescribed style. Don't work on the level of how can I avoid plagiarism? How can I use AI and not be detected? Don't go there. That's not where you want to be. You want to be trained to use AI right and well. You want to be trained to know how to use the prescribed style correctly. You want to know how to write in your own words. So on the 25th and the 26th of March, there will be College of Law writing retreat workshops. In the first semester, we have workshop 1 and 2 on 25 and 26 March. And in the second semester, they are repeated. It's basically the same thing. It's then called workshop 3 and 4, but it's basically a repeat of 1 and 2. So you can attend it now, and then you can do it as a refresher in the second semester again. And here are some of the things that we discuss in these workshops. Things like why it is important to submit your own work, something of what I said now. It's not only about not plagiarizing, it's also about originality. Reading strategies. Those reading lists, do you always really have to read from the first word to the last? Or are there other ways and more ways to read cleverly, with more understanding, to go through more reading with more understanding? So Dr. Shea also has an excellent presentation on that. And when we will be looking at writing skills, you don't want to be at the paraphrasing level where you are inserting synonyms and changing the word order. Who wants to be there? You want to be able to, what is nicknamed power phrase. There's not really a word like that. We will explain to you what we mean by it. It's something that was actually coined by a word that was created by a student in another country. But power phrasing is about discovering your own voice. That out of all the material in that's prescribed for your module, which ones are you selecting? How are you bringing it together? Where are you putting the emphasis? What argument do you choose? The whole approach and how you say this. And please, this is also important. And I think why students use AI is they want their language to be perfect. Your language need not be perfect. What is much more important is your critical thinking, your language improving over time, of course, and being able to express yourself in your own voice. So even if your language is not perfect, I'll far rather take a sincere, honest assignment answer than one that was created by AI because somebody feels she doesn't have the confidence to write in English. So we address these things. We help you to structure your answers. We show you how to prepare and submit your assessments. We talk about artificial intelligence use, how you can actually use it in your studies, not as a source, not as a shortcut, but as something, how AI can help you when you are studying. We will talk about Turnitin, and then our excellent library personnel will be there because obviously your answers are only as good as your sources. So if you can't find sources, then that will not be helping you. Because as we heard this morning, it's not like what you think the answer is. It is how what you've read and understanding the different weight of different types of sources and how you bring it together. And then lastly, of course, we have to talk about the disciplinary processes because at UNISA, we take academic dishonesty seriously. And if you get caught out, there will be consequences. Thanks for listening.
Thank you so much, Prof, for a wonderful presentation. That is significant. Plagiarism, it's not tolerated at UNISA. We do not have a room for that. Our policy is clear in terms of pronouncing how intolerant we are when it comes to plagiarism and the use of AI. And if AI were to be used, as Prof. Khair was saying, it must use within the frames of ethical conduct. Please attend their workshops, their writing retreat, as they teach you all of these things, how to do them within the frames of ethics, So once you take somebody else's work without acknowledging that person, that constitutes a plagiarism because of it's not your ideas, it's not your writings. Of course, it emanates elsewhere, and we have a mechanism in place to detect. We know all of the stuff where there's inverted commas and highlighted in white, or there's numbers in between the writings, so that Turnitin does not pick up. That is an old fashion. We are able to detect, we're able to pick up, and you don't want to attend this disciplinary hearing because harsh, severe punishment, it is administered in them. Thank you so much, Prof, for such insightful presentation.
Prof. Sebanyoni, you are muted.
Ha 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 ha. I've been talking a lot. Thank you so much. Thank you so much for that. I've been talking to
Pleasure.
myself. I've been talking to myself. Thank you so much. I was saying, Prof, thank you for the presentation. Wonderful presentation. There is no room for plagiarism at UNISA. We have a policy that pronounces that and the repercussions thereof. You don't want to find yourself in the disciplinary cases due to plagiarism. Once a material, a source is not acknowledged accordingly, it constitutes plagiarism. And I said that we know all of the tactic. We have mechanism in place to detect some of the untoward behaviors where students will insert inverted commas in a text and highlight them white to fool the Turnitin and so forth, or put numbers in their text. We know all of that, and you don't want to find yourself in the disciplinary hearing. And also, please kindly attend those writing retreat workshops. They are very much helpful. They're gonna assist you students in terms of how to avoid plagiarism, so to speak. With those few words, Prof. Khayer, thank you so much for such an insightful presentation. Now I'll invite Ms. Naidu, librarian. She's a librarian in the School of Law. Ms. Naidu, are you in the platform?
Yes, good afternoon, Prof.
Thank you so much, Ms. Naidu. Your 15 minutes has started. Thank you.
Please let me know if you can see my slideshow.
Yes, yes, can you put it on presentation mode? Ms. Naidu, thank you so much.
Yeah, I have it on presentation mode.
Yeah, it is.
Good afternoon. Good afternoon, Chair. Good afternoon, colleagues and students. And thank you so much for inviting me. I hope you're not too tired to listen and that you won't be overwhelmed with so much of information today. But I hope that in this 15 minutes, I can help you to get started with using the UNISA library and how to access our services, follow procedures, use key resources, and also make use of our reference management tools. So in the library, we have personal librarians, and I'm thinking that now that this session is actually for the School of Law, so I'm going to introduce myself as the personal librarian for the School of Law, and I'm responsible for the departments that fall under this school. But if there are any students here from the School of Criminal Justice, the personal librarian is Trifina Muketsi. So today I'm just going to try and get through to some of the services and helping you to navigate the library website and just show you what are the resources that we have and a little bit more on RefWorks and using OSCOLA citation style. So we have branch librarians and regional librarians besides the personal librarians. And I wanted to say this at the outset that there is a slight difference between the personal librarian or the subject librarian in comparison to the branch librarians and the regional librarians. So in the libraries, in the UNISA library in Makonya campus, we have the subject librarians, and we are responsible for the postgraduate students, particularly the academics and their researchers per se. And our branch librarians and regional librarians are actually responsible for assisting and training our undergraduate students to a larger extent. And if you need to contact them, I've included the email addresses onto this slide. Can you see my slides changing, everybody?
Yes.
Okay, thank you. I'm now on the introduction, and I did this intentionally because I wasn't sure whether there were some students that actually missed the general introduction. So by now, I'm sure you all are aware that we are the largest academic library in Africa. And we have over 1.5 million items, and we have a growing range of electronic databases, e-journals, and e-books as well. It can be a very overwhelming online library. So that is why we have so many training sessions that we have scheduled by our regional librarians, branch librarians, and personal librarians that can help you throughout your research journey. So remember that you are not alone, but you actually need to show initiative. You need to take the responsibility of asking for assistance, and you should be able to navigate this monster of a library website in order for you to make the maximum use of all the resources that we have. So the branch and regional librarians, and I want to reiterate, at UNISA support undergraduate students. We provide access to resources. We offer research assistance, teaching information literacy skills, supporting technology use, managing borrowing services, and ensuring inclusive access. These services are essential for helping distance learning students navigate the UNISA library site and also to help you study successfully. So on the library site, we have services for different client groups, whether it's a postgraduate student, whether it's new students, whether it's services for special needs clients. You should be able to peruse through the different services that are offered. For example, the branches and the opening hours, the literature search service, membership and privileges, training and skill support, borrowing and returning of books. So in this presentation, I'm not sure whether I will have time to zoom into each and every category of service that is offered to you as a new student. But I've actually put the link here, and it'll be very important for you to peruse through the library site and ensure that you become absolutely familiar with the services that are offered or are there for you, and what do you actually need? I have many questions from undergraduate students asking me, for example, where do I find my electronic reserves? Are we entitled to interlibrary loans? How do we access electronic information? Do I need to pay for accessing e-journals? Things like that. So it's up to you to please peruse the site because there are so many options available, so many services. And one of the important services that you should actually take advantage of is the literature search service, where a reading list is provided to you based on a keyword or topic that you submit to our information search librarians. Although this service is offered to you, it is imperative that you still attend our training, because at the end of the day, we want you to become independent searchers. We want you to know how to navigate our databases so you can actually find a case, find a piece of legislation, find a journal article on your own, know how to navigate the various subject-specific databases like Lexis Plus South Africa and JUTA, together with Hein Online, Westlaw, Google Scholar, and many other platforms where you can find legal texts, case law, and legislation. So please remember that although the literature search service is available, you need to become independent. You need to know how to navigate. And there is a wide selection of training sessions that you can opt for. You also need to become familiar with the lending services and know about the different branches or the different regions that are available and what are the services that you can that you can familiarize yourself with. Then in terms of the resources, every year, especially with the new students, they do not know how to access the course reserves. So the course reserves are actually on your tutorial letter 101, and it's available online on our library site on our homepage. You will need to know the module code. So these are your prescribed and recommended readings. And if it's in your tutorial letter 101, but you cannot find it on the library site, you must email us so that we can help you further with trying to determine why those e-reserves are not uploaded onto that module site. Then we have books and ebooks that are available on our Summon search engine and via other databases. Scholarly journal articles, multimedia, newspaper articles, reference sources, law reports, legislation, case law, commentaries, thesis and dissertations. These are just a few. It's up to you to attend the training so that you can navigate the different databases. We have over 500 databases, and we have over 70 databases for law and multidisciplinary databases that you could use for searching. We don't want to overwhelm you. So in this slide, I've just included a few of the databases that you could use. And one of the most important ones that you should become familiar with is Lexis Plus South Africa, Lexis Plus Practical Guidance, and so forth. So if you don't have my training plan, and if you haven't gone onto the library website to look at the training plan for the undergraduate students, please email us so that we could help you further. You will need to register for all our training sessions so that you could get the link to join our sessions. Take advantage of these sessions so that you will know exactly how to navigate these databases and find the information that you are looking for. Then remember the previous speaker, Prof. Hare, spoke about plagiarism, and in order for you to avoid that, you will need to know the importance of referencing. And it's so important because it shows where your information comes from, and you will also be able to give credit to the original authors, which helps avoid plagiarism. So it helps strengthens your work by allowing readers to verify your sources and see the research behind your ideas. And overall, good referencing makes your writing trustworthy, academic, and professional. So the School of Law citation style is the Oscola citation style. And make sure that you have access to your tutorial letter 302, which has the referencing guidelines. So every year I have many students emailing me. It's because you haven't gone onto your module site and you haven't looked through it properly. So you will need to ensure that the tutorial letter 302 is uploaded and you have access to it. So that is where it is. You don't need to email me. I get tons of emails after these presentations. It's up to you to make sure that you can access this via MyUNISA. So students, please make sure that you go to your respective module sites. And also for the training plans, I have many students emailing me. The training plans are available on the module site. So please make sure that you take advantage of that so you could register for the sessions. There are more sessions on the Oscola citation style on the 27th of March coming up. And I'm just going to give a very, very brief account of what does Oscola stand for. Every year, we actually have Tanya Botha from the Department of PCI who does a presentation on Oscola, and I'm not an expert at Oscola, and Tanya Botha has kindly assisted us every year to do the presentation. So the Oscola style stands for Oscola University Standard for Citation of Legal Authorities, and the School of Law has based their referencing style based on Oscola, which is the Oxford University Standard for the Citation of Legal Authorities. It's a legal referencing style used primarily in law schools and legal academic writing. Oscola relies on footnotes rather than in-text citations, and it provides structured rules for citing cases, legislation, books, journal articles, and other legal sources. In short, Oscola is a footnote-based system developed by the University of Oxford to ensure clear, consistent citation of legal authorities and academic work. So if you do not want to do manual referencing, you are most welcome to use our reference management tool called RefWorks. Last year, Tanya was kind enough to do a presentation for us, and I've embedded her presentation in this slide. This year, Tanya has also kindly acceded to the request, which will be on the 27th of March. Please make sure that you become familiar with the reference management tool that helps researchers collect, organize, cite, and manage bibliographies online. This reference tool can help you to store your references in an organized way by using different folders. And you can use the plugin called RCM to generate footnotes automatically. And you can also generate a bibliography automatically. So the School of Law uses the Oscola citation style, and you will need to know how to actually set up the Oscola citation style from the RefWorks management tool. Remember, this training is done over a period of 3 days, and the links are all in my training plan. So in order for you to begin using RefWorks, you will need to create a RefWorks account at this email, at this URL. This is basically what the RefWorks platform looks like. And unfortunately, due to a poor network connection today on campus, I'm not going to go onto the live platform. But if you just go onto refworks.proquest.com, you can create an account. And this is my RefWorks platform where I have various folders, and I've actually set up to use the Oscola citation style. So one thing you will have to remember is that you cannot rely totally on RefWorks. You will have to tweak your footnotes when you are using it or when you are doing the automation on a Word document. So Oscola is the Oscola citation style reflected in the institutional styles comes up as UNISA, Oscola UNISA School of Law. So when you are choosing and when we actually do the online training, we will show you how to choose the correct style. So under institutional styles in RefWorks, you will see a drop down and you will choose Oscola UNISA School of Law. That is the style you will choose. There are various RefWorks user guides. So for those colleagues and students who want to get started with RefWorks and you really have a burning desire to use RefWorks and you can't wait until the 27th of March, you are most welcome to go through all these user guides and training videos that's available. I also have many recordings of the 2025 sessions that we held already on finding case law, finding legislation, journal articles, books, and RefWorks. So it doesn't matter whether you are an undergraduate student, you are most welcome to join my team. And as soon as you click on the link for my student team, I will accept you into my team so that you can go into my training channel and you can view all the 2025 training videos. If you've missed out on the training session for 2026, if there is a session on a day, the next day my training video was uploaded under my training channel. So you can go onto the training channel for 2026 and you will have access to my MP4. Remember, these are unedited due to time constraints, so it's just the live session that you will have access to. So make sure you join my team so that you can get access to my PowerPoints and all the recordings of the sessions. You can also visit the undergraduate library training events calendar from the library page. So you can just peruse through the library page and look for the training and events calendar. These are all the regional and the branch training sessions that are held. Please make sure that you take advantage of all these sessions before you attend the sessions that are scheduled by the personal librarians. You can also email lib-training@unisa.ac.za if you require training that you have missed and you want videos or PowerPoints on the past training sessions. If there are any postgraduate students here, please make sure that you have received my letter of introduction. Remember, at the outset, I said that we also offer services for students with special needs. Please make sure that you peruse the library site in order for you to see what are the special services and resources we have available for students with special needs. In summary, I want to reiterate that the UNISA Library plays a central role in supporting your academic journey by providing access to reliable information, expert guidance, and essential research tools. And understanding how to navigate the library site and the services, following the procedures, and using our vast number of online resources will make your studies more efficient, independent, and rewarding. And ensure that when you want access to electronic resources, you need to be a registered student. You need to use your student number and your MyUNISA password in order for you to get access to our electronic resources. So students, as you begin your first year, remember that the library is not just a place to find information. It is a hub of support designed to help you succeed. This is a two-way road. We need to know that you need our assistance. You need to show initiative and you need to take advantage of all the resources. So make use of the resources, ask for assistance where needed, and explore the services that the UNISA library offers. Your success starts with knowing where to find the right information. You need to link up and network with your personal librarian, your branch librarian, and your research and your regional librarian. And the library is here to guide you every step of the way. You need to start connecting with us immediately. Thank you for listening. That's the end of my presentation, colleagues and students.
Ms. Naidu, thank you so much. I thought you'll see this face and I thank you. Students, support is there. When you say there's no support in UNISA, you read all what you read on social media and fabricated stories and all that. It's not true. Support, it's there. Training plans for library are there. Videos of previous trainings are there on Teams. Everything that you need to know about the library, how to search information, how to cite, what type of citation style, type of referencing style the law uses. You get all that information by being in contact with Ms. Naidu. I can see she's putting some of the information on the chat that you can look at your leisure time. Visit the library website. Actually, visit UNISA website. It transpired that most of students, they don't even go to the website just to navigate about, you know. So go to our website, go to a library website. You would find all the goodies there, and they do have a personal one-on-one sessions where they guiding you how to find information to write your assignment, to prepare for your exam, etc., etc. So please be in touch with Ms. Naidu. Ms. Naidu, thank you so much for your presentation. It's always heartwarming listening to you. I feel like I listen to you every time, but it's like for the first time. Thank you so much for passion and all that. Thank you. And now we are on the Q&A. I see that there most of the questions have been answered on the chats. Thank you so much, colleagues. I see the interaction. Thank you so much, colleagues who are attending to students' queries. This is College of Law. This is School of Law. We are all about that. We are all about rapid response. We are all about prompt response. Thank you so much. I'll open a round of hands for those pending questions that some of the students couldn't ask on the chats. I'll open a round of questions. Any hands to any presentation? Wow. I think we can all attest that this was one of the best workshops, and I hope that your questions were answered on the chats. And if you may have follow-up questions, I believe that you have collected some of the email addresses so you can make your follow-up questions. With that being said, can I give it to Mr. Mahumani to give a vote of thanks? Mr. Mahumani, over to you, sir. Is Mr. Mahumani on the platform?
Yes, I'm here. I'm here, Program Director. Am I audible?
Yeah, you are audible, sir. Thank you so much.
Thank you. Apologies for the technology. Thank you so much.
No problem.
Yes, through you, Chair, if maybe I can describe myself instead of enabling the video. You know, I'm this short guy, not necessarily short or tall, but mid-height, African, of course, chubbish if you like, bold at most times. I often cut my hair. It grows like grass. So that's me. Thanks, Program Director. Yeah, thank you, Professor Banyoni. On behalf of the Tuition and Quality Assurance Office, would like to take this opportunity to express our profound gratitude to you, Prof. You know, for your time and effort in guiding us through the program. You have performed exceptionally well. To all the participants, especially the presenters, thank you for taking the time to prepare and ensure that our students are well informed about the critical issues you've presented. We appreciate all the effort and dedication we have shown towards supporting our students. We also extend our appreciation towards our students to honor this invitation, you know, by attending and engaging with us. Now, we wish you all the best with your studies and success in the near future in the legal fraternity. To the organizing team, we thank you for your professionalism and for ensuring that the workshops are a success. But most of all, the thought, effort, and preparations put into providing and assisting our students in their studies are priceless beyond comparison. Siyabonga, re a leboga, ya cancer, baya danki, re ko leboga. Through you, Chair. Thank you so much.
Thank you so much, Mr. Mahumani. I think there was a consent on the charts to say why can't such workshops and writing retreat be prior before the student make their submissions and stuff like that. Something that we take to heart, we take that comment to heart, and we will improve and do better. Another issue it could be, or it is that we have late students, hence we are having this workshop now. Late registrations, so to speak. So we wanted to cover and cater widely as much as possible for everyone. Hence the workshop now. But we have took stock and will revert to the drawing board as it were. Thank you so much for attending, colleagues, and thank you for listening to me. Have a wonderful afternoon. Goodbye. Bon voyage. Thank you.
Bye, colleagues and students. Take care.
Thank you very much. Goodbye.
Thank you,
Thank you,
everyone.
everybody.
Bye.
Bye-bye.